films, narratives, documentaries, press services, and programs on location or outside live broadcasting of mass and other church functions, government or indoor functions, and political enterprises. All services are offered at competitive prices. Tune in daily to catch Luntha television on Zuko on Channel 51, Starsat Channel 474, Star Times Channel 474, Topstar 474, Kriye 007, GoTV on Channel 807, Azam on Channel 386, and live streams on our YouTube and Facebook platforms.
So that they can walk in, but I will not wait for them. Let me appreciate the role that you've played as Secretariat, because you've helped us to clear those who were celebrating victory of others in no time. Thank you so much. I hope they're going to take those who won, they are going to take it as such, because you had to curtail their celebrations within Parliament building because they were making a lot of noise. So I hope they're going to forgive the committee, because the committee is deliberating on serious matters of the state. AG, I had requested you to pause when there was that too much background noise, so you can pick it up from where you stopped. You were responding to a question from Nkatabe Central. Over to you, AG.
Thank you, Honorable Chair and Honorable Members. As regards the purchase of Sigregi Hotel by the pension fund, I'm meant to believe this happened prior to my appointment, so I do not have sufficient details. Therefore, I'm unable to say much, but to emphasize that not between 27th October 2025 and now, so I'm not much aware of what happened. The minutes of the meeting of March 2024, yes, I have seen them. I have gone through them, and indeed, I read in them that the Secretary to the President and Cabinet, Madam Zamba, chaired that meeting and also did give some directions to the members, the members of the fund, including indicating deadlines when certain things had to be done in respect to the purchase of Amaryllis Hotel. That's how far I can say, because that's my knowledge is purely based on the minutes. That's what I could say.
I see a hand from Nkatabe Central, but you may recall, Nkatabe Central, that in our engagements, background engagements on Wednesday, I was guided to make sure that each and every member is given a chance to ask questions. The more reason I had started it this way. When on Thursday I did the same, members also complained, because there was a time people said that I'm dominating. I had to take a step back, and I was accused. So I want every member to take it, to have a chance. Unless there's a burning one from you as a senior Nkatabe Central, you still feel it's too burning that you need to come in?
Yes, Chair.
Please proceed.
Thank you very much, Chair. The question about Sigregi Hotel was about the office. I know that it happened, it took place when we were not in the office. I know that. But the question was the office of the Attorney General involved? Not you as a person, but the office. That was the question. About the meeting in Mzuzu called by Madam Colini Zamba, the question was to ask you whether you have accessed the minutes, to which you have confirmed yes. Now, I want you, if possible, Chair, to read those minutes. It's one page. Read the minutes for the benefit of the committee and the entire nation. Read the minutes. Thank you, Chair.
Thank you, Nkadabe Central. You may recall on Thursday in the evening, Luntha Chiromoni Nancholi had to go through the minutes. You want the AG to read again?
Yes.
Is this a general feeling of the committee?
Yeah. He's reading to the nation now. We're talking to the nation. Read the minutes. Don't be defensive. Read the minutes of that meeting. It's one page.
Attorney General, kindly go through the minutes that you have. Over to you.
Honorable Chair, it's actually 4 pages. Can I be guided which specific part? Is it the last part where the action plans or? Oh, okay. So these minutes were for the meeting that was held on 6th March 2024, and the present were Ms. Colleen Zamba as Secretary to the President and Cabinet, Mr. Pris Kabondangaga as Chief of Staff at State Residences, Mr. Chizaso Nyirongo, Director of Legal Affairs OPC, Mr. Boyd Hamela, Chairperson, Investment PSPT, and Mr. George M. Jim as Principal Officer. Let me start with action point number 1, which is under paragraph 3. So action 1 says, the fund was notified that soon it will be invited for the PAC's meeting to present the overview, so the fund must be ready. Action 2, the fund was advised to reach out to the SPC on the challenges the fund indicated, which included the delayed remittances, data disparities, the issue of past service liabilities, and non-submission of beneficiary nomination forms. Under 4, which was governance of the fund, action number 1, OPC suggested that a person from the OPC should be a trustee for easy flow of information of the fund's developments to the SPC. It was mentioned that DHRMD, which is a department under OPC, is represented. Action 2, OPC advised that the replacement of trustee Kahaki Jere, who was from the Ministry of Justice, should be through the OPC so they can play a role in scouting the replacement. Under item number 5, which is status of investment of the fund, action 1, the OPC instructed the fund to move with speed in concluding the Amaryllis transaction before the end of March 2024. Action 2, the threats for lawsuits are coming in because of the pressure the seller is getting from the lenders. To query the pressure, the fund was advised to write and give the seller the comfort letter by Thursday, 7th March 2024. Action 3, the fund to submit a workable action plan by Friday, 8th March 2024 to the OPC for their ease of follow-up. Action 4, being that the issues has raised the highest office, the fund was advised to report on weekly basis the progress made in this transaction. Make communication to the Director of Legal Services, Mr. Chizaso Nyirongo. Action 5, the fund to engage the next investment manager on the Amaryllis completion by 8th March 2024. Under conclusion and way forward, I think there's what they labeled as action plan for the critical issues, 6th March 2024. Number 1, communication on the replacement of the trustee that left to replace with OPC nominee. The status, communication that was sent to be addressed to the OPC. 2, conclusion of Amaryllis transaction with March, timelines 1 month, and status, the issue requires board decision. 3, submission of comfort letter to the seller, timelines 3 days. 4, fund to submit the action plan to OPC on 8th March 2024, timelines 5 days. 5, resuscitating the engagement with the next investment manager on Amaryllis within a month. I suppose, Chair, that's what I could read from this report, and perhaps just to also emphasize that I have not, in my time in office of the Attorney General, I have not come across any documentation that shows that the Office of the Attorney General was involved in the purchase of Sigerege Hotel. Thank you.
Katabe Central, are you okay?
Very much, Chair. Perhaps the last question would be, there's a mention there of weekly reports to OPC since the matters have reached the highest office. The one chairing that meeting was the SPC, the Secretary of the President and the Cabinet. And the reports are saying the matters have reached the highest office. Beyond OPC, how do you define the highest office? Thank you, Chair.
Thank you so much, our senior Katabe Central. Attorney General, you may take that one. As you take that one, you've also gone through a submission or a recommendation that sale was supposed to be concluded within 1 month. But this sale was concluded on 17th November 2025. In your view, was that directive followed? Over to you, Controlling Officer.
I can only think that perhaps the highest office could have been that of the President, considering that it was the Secretary to President and Cabinet. But usually I take it that documents speak for themselves. So this is me just thinking, but otherwise the document does not mention the Office of the President. Yes, the document also shows that this transaction had to be concluded within March 2024. And indeed, the sale agreement that I saw was concluded in November 2025. Suffice to say that the only thread that I am able to connect is the fact that those minutes were mandating Mr. Chizaso Nyirongo to be in contact with the fund. And from the minutes, at that time he wasn't a member of the fund. He was Director of Legal at OPC. But at the time of conclusion of the sale agreement, he was the chairperson of the fund. So I'm not sure whether I could say with certainty that that directive was followed to the letter, or maybe it just dragged on to where finally the chairperson of the fund and other trustees concluded the transaction.
Thank you so much, Eji. Can we go to Lilongwe Chiwamba? Lilongwe Chiwamba, please.
Thank you very much, Chair. Allow Lilongwe Chiwamba to ask only 2 questions. Eji, you wrote a letter on 28th December 2025. What exactly did you advise the fund? Secondly, AG, were you aware that asset finance managers advised the experts, provided expert advice on the same issue? Thank you.
AG, can you take those 2 from Lilongwe Chiwamba? Over to you.
Thank you, Honorable Chair and Honorable Member from Lilongwe Chiwamba. my advice to the fund was simple and straightforward. Attend to all the prudential risks, review them, find mitigating as well as management, ways of managing those issues. And this is coming from a background that transactions do normally carry risks, but that's where those making decisions must look into those risks and see whether they are mitigatable or manageable and take a decision. So that's what I did advise the fund. And of course, only to proceed with the transaction if they are satisfied that they've addressed those prudential issues. Yes, I saw some documents that showed that asset finance managers were involved in the transactions. Actually, I saw documents from FTH that were done on behalf of Nico. Now saw documents from Continental Asset Management Limited. And of course, the last one was from EMJ Advisory. Thank you.
Thank you so much, Attorney General. Can we go to Luntha Chilomoni?
Thank you so much, Chair. Permission to interrogate the AG for about 5 minutes.
Since we already said the precedents, and I've always been giving you such a request, and it has always been granted. So permission granted. AG, what will happen? I'll not interrupt. All I'll do, I'll give to Luntha Chilomoni Nancholi Kabula constituency. As soon as he switches off his mic, then you can switch on your mic. Immediately you're done, kindly switch off your mic. Then Luntha Chilomoni Kabula Nancholi will come in and will proceed in that way. Over to you, Luntha Chilomoni.
Chair, I'm going to quote the submission by the Attorney General, where he says on the page 2, we go straight to the text of the advice, where he says, in my letter to Malawi Law Society on the 28th December 2025, copied to the fund, I stated, and I quote, and the following is the quote, in view of the magnitude of the transaction in this matter, and indeed out of abundance of caution, and in order to ensure that members' savings are protected within the prudent investment principles of the regulatory requirement, and the board is advised to once again review the attendant risks and satisfy itself with the available mechanisms for the management or mitigation thereof. Once this is done, the board is advised to proceed and conclude the transaction in the best interest of the fund and its members. In this letter, why did you say that once the issues are fixed, then the board should proceed and not may proceed?
Thank you, Chair, and thank you, Honorable Luntha Chilomoni. To begin with, the fund is founded on a trust deed, and that trust deed vests the power to invest in the trustees, and actually they have absolute discretion. So I was mindful that already the power to proceed or not to proceed is in their hands. So I needed not appear as if I'm restricting them on the powers that they have been granted absolutely by the trust deed. That is the reason why I was merely giving them the very thing that they already have. Thank you.
In your opinion, Attorney General, was the transaction conducted in accordance with the laws of Malawi, specifically the Trustees Act and the Pensions Act?
Through the chair and honourable member, the compliance with, say, the Pensions Act, the regulatory framework, including directives from the Registrar of Financial Institutions, the governor. Those were some of the issues which were raised. The prudential element of it included certain things, for instance, on concentration lists. Those come under directives from the Registrar of Financial Institutions. So those were some of the issues which they needed to attend to. So there were such issues that if they were attended to, they would have resolved the element of compliance and therefore they could proceed. So if they did not attend to those issues, at the time when they finally made payments, they would not have complied because they were issues that were actually highlighted. That's why my emphasis was, can you attend to these issues? That was, in a way, telling them that make sure that even the other regulatory issues that have been raised, which are legal in nature, must be complied with. Thank you.
In your submission, you actually indicated that the final decision maker, in any case, according to the trust deed, are the trustees, correct?
That's correct, sir.
Why do you think, in your opinion, therefore, that there was political interference between March 2024 and September 2025, specifically where Colin Zamba had the power to instruct the board or the pension fund what to do? Do you think that anyone else other than the trustees has that power, or Colin Zamba was acting at reverse or outside the power?
Through you, Chair, I've looked at the trust deed establishing the fund. There is nowhere where the office of the Secretary to President Cabinet is specifically mentioned. So, again, if I were to look at whether she had powers, maybe to give directions like she did, at the very least, I would say that's not founded in the trust deed. Those powers are not granted to her. And like I've already said, the powers are vested in the trustees, and they have actually been given absolute discretion to decide on what to invest in. Thank you.
In your submission, you explained that you toed the same line with the Anti-Corruption Bureau in coming up with your opinion, because the Anti-Corruption Bureau never found any corrupt activities in the process. Do you think that basing your opinion on the Anti-Corruption Bureau in this case was the best decision you could do as the Attorney General? And I'm asking this because assuming that the Anti-Corruption Bureau has missed something, don't you think that then, in that case, your decision will also be compromised because you have based your decision on some other office and not your own independent decision?
Through the Chair, to begin with, the Office of the Attorney General is not an interrogator, is not an investigator. So that's the reason why when I received that complaint from the Mar Law Society, I referred it to the Anti-Corruption Bureau because they have the capacity to investigate matters to do with corruption or fraud. So there is a presumption of legality that when one thing moves from one properly established office to another, unless something clearly appears to be wrong, you can't just assume that they haven't done the right thing. So the office that's mandated to deal with matters of corruption in Malawi is that of the Anti-Corruption Bureau. So I trusted in their opinion because they are the ones that have got the capacity to investigate. So in my view, remember I said as a legal advisor, you base on facts presented to you. You don't create your own facts. So the fact remains that in their report, the Anti-Corruption Bureau clearly indicated that they did not find any evidence that suggested that there was corruption. So I believe that my opinion was not in any way compromised because of the regularity principle that I had to use under the circumstances.
Two more questions. I think you are holding an office, but you are also a human being and an individual, such that most of the times it's also good to go beyond just the office. As an individual, Mr. Frank Mbeta, the value of the hotel from 30 billion to 47 billion, then to 128 billion, then to 145 billion. You didn't smell any collusion, any corruption in this change of price within 1 year as an individual, not as the Attorney General.
Chair, I'll be quite reluctant to answer, but nevertheless I'll take it because I did undertake this exercise in my official capacity. However, the movement in the prices, I did actually, yes, say there's significant movement, but in my letter to the Law Society, I said it will be difficult for me to fault the pricing because that pricing was done by experts that do the pricing. I personally wouldn't want, and again, with my background as a lawyer, I know that when you're dealing with expert evidence, you really need to have a compilator. You don't just go and begin faulting expert evidence because you would have, as a person, thought maybe it should be done in this way. You normally would want to go to another expert and say, what are we saying here? But that wasn't within the framework of what I could have done. But in addition to that, when you look at some of the prudential risks that the Reserve Bank had raised, they had to do with the price. So when we were saying, can you attend to these issues? We were essentially saying, look at everything holistically and be sure of what decision you are taking as fiduciary persons. So yes, the movement could have raised eyebrows, but corruption is something that ought to be proved, or at least there must be clear indicator that, or something at least that you can clearly say this points at corruption. So coming from a point where the Anti-Corruption Bureau said we haven't seen any elements of corruption, I didn't really find it as an issue on its own. But also to mention that, in my view, overpricing is not equal to corruption. The hotel may have been overpriced, but of course I don't have the expertise to be able to speak to that clearly. However, there ought to have been some indicators that would actually make you think that there's corruption. So I wasn't able to form that opinion for fear that this is something that was coming from expert assessments. And most importantly, you have the trustees that must actually look into the pricing issue. And also because they negotiated for the price. What were they negotiating for? What were the parameters that they could have used? So remember, that's in their absolute discretion. So I had to stick to my limits. Thank you.
Finally, Chair, what do you think?
Honourable members, I'll give you a chance. Don't worry. Let us allow Luntha Chiromoni to finish, then I'll get to you. You can formulate substantive questions. Each and every member will be given space to ask. Luntha Chiromoni, kindly proceed.
I think what's coming out very, very clear is the fact that all the powers to make investment in terms of the pension fund rests with the trustees. That's coming out very clear. And when I asked you about the increase in price, you said the increment in price does not really indicate that there is an element of corruption, but can also indicate that there is very high element of corruption. In your opinion, Attorney General, what do you think is the value of Amaryllis Hotel? That's my last question. Thank you, Chair.
Through you, Chair, I don't think I know, or I'm in a position to say what value the hotel could be. Because I'm aware that valuations of businesses that are actually running take so many parameters. So I don't think I would be in a position to say how much it's worth. Thank you.
Thank you, Luntha Chiromoni, for those submissions. But listening to the Attorney General, you can actually see that there's hibernation of legal formalism. Because in your submission, just listen to you said corruption must be proven. But Attorney General, the idea that corruption must be proven, is it legal? And you went on even to talk of conditional approval. So if you're looking at advice, the advice was conditional approval. Don't you think that was an attempt to shift responsibility as an Attorney General? Because at that stage, it's like you're limiting your mandate. The moment you limit your mandate, then scrutiny stops. Attorney General, is it your position that the transaction is legally sound so long as no evidence of corruption has been detected or established? Over to you, sir.
Yes, I will not divorce myself from the lawyer and me. Corruption, there must be indicators, there must be some pointers which, when investigated, will point at or prove that there was corruption. It is what it is, just like any other offense. Conditional approval, like I said, I was not approving the transaction. I was telling them, attend to the prudential issues first before you go on with the transaction. That, in a way, was not even limiting my mandate, because to begin with, my mandate in this particular regard was really on thin ice, because this is an investment issue by the fund, established by a trust fund. It's not even a parastatal, and the trustees have absolute discretion in deciding what and how to invest. So I was not limiting my mandate, but I was merely pointing out to them and emphasizing what had already been pointed to them by the Reserve Bank of Malawi, that there are these issues which they must attend to. I hope I have answered your question, Chair.
Thank you, AG. Your advice centered around risks being addressed, that there are these potential risks. Can you address them on this? Those conditions, do you think at the end of the day, were they addressed, that as AG, having highlighted those risks, when you noted that the agreement had been signed and payments have been made against what you had advised. Do you feel that at that stage when the payments or the agreement was reached, they had addressed to what you had noted as gaps within what the submission that you got as AG? Over to you, AG.
Thank you, Chair. It needs to be appreciated that by the time this issue is coming to my office, a SERA agreement, which on the face of it looked to be a valid agreement, had already been signed. But nevertheless, I was mindful that people do actually go through what they've already signed and realize that certain things could be done differently depending on how the agreement has been drafted. So the difficulty there is that it would have been a different scenario if they had come to this issue had come to my office before they signed, but they had already signed. So there was already a valid agreement between the parties. So when it comes to the addressing of the issues, like I've already indicated, the fund did submit a dossier of documents regarding how they have addressed the issues. However, like I already said again, I was mindful that even if they were to submit those things to my office, the right authority to go through those representations and form an opinion whether they have addressed each and every one of the receipts adequately is the governor of the Reserve Bank, because that's the regulator and also with the capacity. That's why in my presentation I said I hope and believe that the regulator has already gone through or will go through those documents to see if those issues were fully addressed. Now, I'm not in a position to know whether by the time that payments were being made and all, this dossier was already given to the regulator, and whether the regulator had already gone through them and taken a position on those issues. Thank you.
Chukwawa West.
Thank you very much, Chair, and thank you very much, Attorney General, for your presentation, well detailed. The ACB appeared before this committee, and they informed this committee that during their investigations, they didn't find anything about corruption, and also something about the abuse of office. The DG went on to say that notwithstanding, it noted some serious risks and referred these issues to you. Maybe for the benefit of the committee, what did you do when you noted those risks? Secondly, you have mentioned that you received a dossier from the fund which contained documents explaining how the fund was dealt with the attendant risks. For the benefit of the committee, maybe when did you receive the dossier? Thank you very much, Chair.
Thank you so much. Attorney General, you may take those from Chukwawa West.
Thank you very much, Chair. Thank you very much, Chukwawa, Honorable Member from Chukwawa West. Indeed, in the report that the ACB wrote to me, and of course the cover letter, they did indicate that they did not find any elements of corruption or abuse of office, and that they talked about the receipts which they acknowledged were not within their mandate to interrogate or at least form an opinion on, and they referred those issues to me. And that is why in my letter to the Law Society, the last part which I read, I was telling the fund to attend to those serious receipts. So that's what I could have done under the circumstances, because those serious risks had to be attended. Somebody ought to take responsibility for them, analyze them, take positions, or if there are any issues, any things they need to do or to reintroduce into the whole setup in order to deal with those issues, they could do that. And those are the trustees. That's why I told them, can you attend to those risks? The dossier, in my recollection, I think I received them towards the end of February 2026. Thank you.
Honour members, I had given a chance to honour members to raise issues. So on the first round, I see a hand from Lilongwe Mpenu. I see a hand from Palombe Machemba. There's Chikwawa North. I see Lilongwe Chirobwe. I see Lilongwe East. We'll start with the Vice Chair. Vice Chair, over to you.
Thank you very much, Chair. Good afternoon, AG.
Good afternoon, Honorable.
Thank you, Pana Chair, for giving the people of Machinga Likwenu to ask the AG one or two questions. AG, given the allegations of a suspicious transaction and an exorbitant price stated by questionable valuation from an unregistered company linked to self-proclaimed experts, how do you respond to accusations of deliberately ignoring potential wrongdoing in the hotel sale? 2, what specific measures will you take to investigate these claims, hold those responsible accountable, and restore public trust? Thank you, Chair.
Thank you, AG. On top of that, in your indication, in terms of the pricing, you said the inflation of price in itself is not an indication that there was corruption, but you indicated that you respect the experts. But when you're looking at EMJ, who formed the basis of the transaction, which he had done his work within 10 days and he concluded everything within 10 days. In your view, AG, or are you still standing to your view that you did due diligence? If such a person or such an institution misguided the whole transaction, because everything revolves around EMJ, whose procurement process was faulty, expertise was questionable. Did you at any point when you are doing due diligence engage Secretariat on this person, EMJ? Over to you, Controlling Officer.
Thank you, Chair. I would want to seek your indulgence, the Vice Chair. Your first question, I don't think I've heard you correctly. Would you mind repeating it?
Thank you, Chair. Given the allegations of a suspicious transaction and an exorbitant price stated by a questionable valuation from an unregistered company linked to self-proclaimed experts, how do you respond to accusations of deliberately ignoring potential wrongdoing in the hotel sale? Thank you.
Bana Echi, over to you.
So, okay, the part I wanted to understand in that question is the accusation of deliberately ignoring potential wrongdoing. Whose accusations? Towards who? Because so that I am clear in responding.
It's to you too, AG.
Okay, thank you very much, Chair and Vice Chair. Actually, I do not see where, as Attorney General, did I ignore anything in this particular transaction. The issue of EMG being unregistered, whether they have correct qualifications or not, is a factual issue. It was never brought to my attention. Even when I asked the fund trustees, they did not suggest to me that EMJ was not registered. But again, registered by who? Is it, because these are finance experts, are they people registered to their respective boards or whatever? Those facts were not before me. Therefore, I could not have ignored what is not known and what is not before me. And again, like I said, when you talk about suspicious transaction, the different allegations made by the Law Society were actually addressed either through the report by the SCB, which made some findings on specific issues, or the Reserve Bank report, which also made findings on various issues. These people actually went out there and investigated. So if those institutions did not label this transaction as suspicious per se, it could not have been proper for me to simply just say this is suspicious. In terms of what action the Attorney General can take, I've said this is a fund established under a trust deed. Only if I am presented with the grounds for which certain actions will be taken, then the actions will be taken in accordance to the law, be it trust law, common law generally, or statutory law as it were. So it will be preemptive for me to take an opinion at this point when facts are all over the place, they're at large. There's this, there's that, there's that. So if I were given a set of facts that this is what we have found, what would you do? I'll be able to advise what the law would allow me to do. Chair, your question on the reflection of price, not an indicator of corruption, and you've talked about being unqualified, the procurement not having been properly done, and all. Firstly, when I looked at the reports by all the three the three valuers or assessors, I think the issue of how they've been procured wasn't raised at any point. And each one of them, they had indicated in their reports how they went about the whole assessment process. And therefore, there was no fact on which I would have grounded an issue to do with the procurement processes, and also no ground on which I would have raised an issue to do with the qualifications. Again, like I said, the broader spectrum of qualifications would have looked at issues to do with whether the assessors are properly trained in their field of assessment. Then there are also issues of licensing and all. So those are issues I couldn't just raise anyhow unless they were brought as a fact. And even the Law Society, in my recollection, I don't remember them raising an issue to do with the qualifications of EMJ. So I only advised on facts that were available. Thank you.
I had recognized Lilongwe Mpenu. Lilongwe Mpenu, please.
Yeah, through Chair, can I take leave of you just like Luntha Chilomoni did? I've got a number of questions, so if I would be allowed to ask the questions one after the other, with your permission, sir.
Lilongwe Mpenu, you will be given that chance because it has been the practice. So, Attorney General, Lilongwe Mpenu, how many minutes? 3 to 5 minutes. 5 minutes. Okay, you get those 5 minutes. Attorney General will proceed like the way we proceeded with the Luntha Chilomoni Kabula Nancholi constituency. Over to you, Lilongwe Mpenu.
Thank you, Chair. Honorable Attorney General, let me begin by saying I do appreciate the fact that your office deals with matters of legal opinion on questions of law as they apply to facts. You cannot cook facts. Facts speak for themselves. In accounting, there is what we call creative accounting, in which the reporter takes advantage of loopholes in financial regulations to inflate profits, deflate expenses, and hide liabilities, for example. So a transaction would be given a face of legality, but then it doesn't address matters of ethics and morality. Looking at what has happened in this whole transaction and through our interface with different stakeholders, Reserve Bank, for example, it transpired that EMJ is not a registered business follower. And according to the central bank, an entity is not registered as a business follower. When they're registering, they register individual, physical beings as business followers. So when you look at the whole transaction, the trustees and what transpired, do you at this point, for example, regret that you relied on what would be called professional advice from EMJ advisory, for example, having gathered these facts at this point? And again, it has transpired that let me connect. In your paragraph on due diligence, you failed to mention NICO asset managers. I don't know whether that was by design or by default, because the NICO asset managers specifically advised against this transaction. So my question at this point is, do you regret having given advice, legal advice, based on EMJ, who it happens is not registered? And then there were other advisors who specifically advised against the sale. Maybe you can take that question, Chair.
Thank you, Chair. Regrets on relying on EMJ reports. I think that's a question that probably the right people that should have answered it are the trustees, because they are the ones that place reliance on that valuation. I was not in a position to place reliance on that, but I recognize the fact that they had engaged a business valuer, just as they had engaged other valuers before. So that regret, or perhaps a question of whether there'll be regrets or not, I'm sure the trustees would be in a better position, because they are the ones that made the decision at the end of the day. The issue of not mentioning Nico asset, you notice that I've mentioned the FDH. Remember that Nico asset, from what I gathered, they did not do the evaluation of the business themselves. They engaged FDH. So if you were to look at a report, you will not be looking at a report, at least what I was presented with, you will not be looking at a report that is done by Nico Asset per se. It's a report done by FDH on behalf of Nico Asset. So I was mindful that if we are looking at what business report, evaluation report was made available, I did not see one that was done by Nico Asset. It is FDH that did the evaluation, at least from the facts that I gathered. So again, those are the facts that I had.
Chair, in your response to the Malawi Law Society, it appears it was cut and paste from the letter written to you by the Acting Director General of the Anti-Corruption Bureau. Yet, as an office, you had the latitude to conduct your own due diligence to ensure that your response to the Malawi Law Society, for example, was your own and not necessarily that of the ACBs. And Chair, that question also builds on the fact that it has transpired that the ACB now acknowledges that through these interfaces, certain facts that they didn't have emerged. As a result, they have reopened investigation.
What's the question? Because I think you made a statement. The question is?
I asked a question that your office could have conducted your own due diligence to ensure originality of your response to the Malawi Law Society instead of depending on the response to you by the ACB.
Thank you, Chair.
Maybe, AG, before you take that one, just to supplement on what has touched on, that the ACB has reopened the case, and at the same time, the Reserve Bank, which is a regulator, has actually withheld the funds. As we're speaking, we're looking at about 72 billion. With the guidance that you got about the whole transaction vis-a-vis the pricing that it was higher, do you still stand to your earlier position that the transaction was not was okay? There were no corrupt elements. Now that you have new information that even the Reserve Bank has ended up quarantining and actually freezing some of the accounts in relation to the same. Over to you, controlling officer.
Thank you, Chair. Honorable member from Lilongwe Mpenu, I take it when you say that we could have conducted our own due diligence, you essentially are talking about our own investigations. Is that the context in which you are asking that question?
Not necessarily your own investigation, but having been presented with the facts, you needed to dig deeper than just relying on the submission from the Office of the Anti-Corruption Bureau in your response to the Malawi Law Society. That's the context.
In my letter to the Law Society, you will notice that I did indicate that I also did my own investigations. So what I found mirrored what the ACB found, because remember that the people that were being interrogated are more or less the same people, and the same findings were repeated in the report by the Reserve Bank governor. Again, it's because we were all questioning the same people. They gave the same answers. So, to emphasize that I did investigate, and the answers given at that point were more or less the same as those that ACB brought, more or less as those that were found in the report by the Reserve Bank of Malawi. So it wasn't really about cut and paste. The facts played out in that fashion. So I couldn't have presented facts any different when they just played out in the manner they did.
Officer, can you switch off your mic? When you're looking at the facts that they were similar, did you go through the submission by Malawi Law Society where it actually raises concerns that the EMJ was a collusion? In their view, if you go through the Malawi Law Society submission, it actually indicates those things. So when you're looking at EMG, in your, if it was similar, whatever, because you're engaging probably the same individuals, in that report, did you find, in your view, that the EMJ was an expert? And as you're talking of those findings, did you manage to refresh yourself in terms of the period EMJ took to arrive at providing such an independent expert submission? Over to you, AG.
Okay, the issue of EMJ being a collusion, I think that's an allegation that at the material time when the Law Society wrote to me, they didn't talk about collusion. So I wouldn't have imagined that an assessor that would actually be contracted to assess such a business, a huge business, as it turned out, would have been collusion, unless if they had raised it, because the things that they did raise, they were attended to. So the collusion part is probably, that's what maybe they presented in their submissions here. But if you're in my shoes at the time when I was giving my opinion, you would appreciate that I couldn't just pluck this from somewhere. There wasn't such an issue. Yes, I'm aware. The RBM has frozen the funds. The SCB has reopened the investigations. But perhaps just to be sure, at this point, do we have anything that already points at that elements of corruption have been established? Or we are still waiting for those investigations? Chair, I just wanted to be clear in the question in the manner in which this question came through on the issue of corrupt elements.
Basically, you're looking at the Reserve Bank rescinding the decision, or still towing along what they had advised, that this transaction was not supposed to proceed because there were elements which pointed to corrupt acts, to the extent that having noted that they had advised, but the board proceeded with a sale agreement. In fact, your office actually advised on not to, unless few other things were handled. But the fund proceeded to actually sign a sale agreement where even Malawi Law Society had raised issues of conflict of interest with EMJ and the owner of the hotel. All those things are contained in the submission that Malawi Law Society gave to Parliament. So I thought you are aware of some of those things and elements. The more reason I wanted to find out from you that having had that the regulator now of financial institutions has quarantined some funds, even with the banks which were involved, even other individuals, including the account for Amaryllis Hotel. Do you still feel that the guidance that you got was valid? Thank you, AG.
Yeah, thank you, Chair. The difficulty in the line of question that has been made there is that an opinion is being sought based on precautionary steps taken by the Reserve Bank as well as the SCB. I would think that giving an opinion has to be based on facts, the actual facts that go to the root of the issue. As I sit here, I do not have any document, official document, either from the Reserve Bank or from the SCB that actually details out, let's say, elements of corruption, who was involved, what they did, and everything else. It will be difficult to form an opinion unless such facts are made available. And again, freezing of funds, like I said, it's more of a precautionary measure. It depends on so many factors at play. And I haven't seen the documents that the SCB, rather the Reserve Bank, has used in freezing the funds. I don't know whether they obtained a court order or maybe they went through the Financial Intelligence Authority, which probably seems to be what I gathered. So in all that, there are some facts that are speaking to that decision to freeze the funds, which I do not have now. So again, I cannot just form an opinion. If those facts were made available, I would certainly form an opinion. But then as far as the opinion that I formed on 28th December 2025, it was correct to the extent of the facts made available. Thank you.
Oliro Mwempenu, can you wind up? Your 5 minutes is almost done.
You intercepted me, Chair. Well, Chair, is it consistent with your office's constitutional duty to ensure legality and procedural compliance that the fund engaged EMJ to conduct an evaluation in the Amaryllis transaction when EMG was not registered as a valuer in accordance with the relevant statutory framework governing professional valuation practice in Malawi? And further, if the applicable law requires that proper valuation be undertaken only by duly registered valuers, does the engagement of EMJ not raise questions as to the legality, validity, and enforceability of the valuation relied upon in the transaction, and consequently due process? Whether due process was observed. AG, you submitted to this committee that you are confined to the legality. So this question builds on that. And I'm asking, okay.
It's you on the mic, so that's why I was waiting.
Okay, sorry. My
Thank you. Okay. The fact of EMJ not being registered under whatever framework, it is a fact that ought to have been made available if it were to change the opinion that I would have formed at that time. It wasn't there, so it remains what it is. It was never there. So I couldn't have formed an opinion on what is not known or what is not made available. But again, you might wish to know that the Reserve Bank, as a regulator, they do have wider powers. Maybe that's why they do register some of these valuers. And In any event, in the letter that I saw, firstly in the report that they sent to me on 25th December 2025, as well as the subsequent letter which they wrote to me on 6th January 2026, but received on 10th January 2026, the Reserve Bank didn't come out clear-cut to say rescind the transaction or this transaction can never be done. They said, can you address the risks? And in particular, the letter of 6th January 2026, the governor said, satisfy my office on the viability of this transaction. He didn't even talk about EMJ advisory. So again, we're still at the point where the information made available would influence the nature of opinion that you give on something. So this doesn't in any way compromise the consistency of my constitutional duty to provide legal opinions. Now, the issue of whether EMJ not being registered will affect validity, enforceability, and due process of this agreement. Firstly, I must put a disclaimer that I'm not giving an opinion per se, because you have several players here. You have the seller on one side, and then you have the buyer, and then you have the Reserve Bank of Malawi as a regulator. The legal framework that the regulator looks at when it comes to managing financial institutions points at the financial institution. Have they done ABCD correctly or not? And if they find that they haven't done the correct thing, what are the remedial measures? Which is why you will notice that in the most recent letter I saw from the governor, where he suggested that suggest direct or whatever, say to the pension fund, can you have so much number of days to rescind the contract? He did mention that satisfy me why I should not penalize you. That speaks to the regulatory framework that the governor uses when it comes to financial institutions. So the example would be, if you own a bank and you do some illicit forex transaction, the governor will not go to me as a person who bought the forex from you to say you bought wrongly, can you give us back the dollars? They will go to you as the financial institution and penalize you. So the point I'm making is, it is important to understand the legal framework in which these things are arising. What the governor would do is properly regulated by law, but against who? What is very clear from all the laws that the governor would do, they point towards the financial institution, because that's their subject. That's what they are regulated. That's what they're mandated to regulate. On the other hand, you have the seller. So in law, we talk about the famous Tarquin case, so we talk about the Tarquin principle. There are issues to do with indoor management rules. So all these things that we're debating here, they have to do with how the fund or the trustees conducted themselves in making their decisions, which is an internal issue within the trust fund. On the other hand, you have the seller who offered and eventually negotiated with these trustees for whatever price that they could have offered on, and eventually did agree with the buyer. The court, probably at an appropriate time, they may have to examine how does the indoor management rule come to operate in respect to this particular transaction, because then that will affect the issue of validity, enforceability, and due process. So it is important to understand that when you look at the fund, which is what we're questioning now, what they do internally and eventually enter into a contract with the seller, the regime that we're going to use in terms of the legal regime is different. So it is pretty much difficult for me to say whether this contract will remain valid or enforceable, because you would have to examine all the facts as well as look at what legal framework are you using, because the other legal framework does not go directly to the seller. The seller is not a financial institution. The Reserve Bank governor does not have automatic powers on the seller. So it's important that these things be understood in their context and the legal framework that's being discussed, and therefore I'm unable to give an opinion on the issues of validity, enforceability, and due process in respect to the fact that EMJ was not licensed. Thank you, Chair.
Yeah, my last but one question. ACB in their submission, they said they observed that some of the matters that had to be investigated were out of their mandate. For example, issues of investment and fraud. And they submitted to you as AG to take the same to relevant offices or take appropriate action. What did you do after receiving the submission from the ACB? Did you, for example, advise the Financial Intelligence Authority or Fiscal Police to investigate? If you did not, why?
Chair, I did mention that the issues that the ACB said were out of their mandate, they had to do with the very issues that are within the mandate of the Reserve Bank of Malawi. And the Reserve Bank of Malawi had sent me a report on 25th December dealing with those issues. So there were answers. They were attended to because the Reserve Bank was conducting their own investigations, whilst the ACB was conducting their own investigations, which is why I emphasized that when I was forming my opinion, I waited, apart from having an interface with the trustees and everybody else I could ask questions regarding this issue, I waited for reports from the ACB and the Reserve Bank of Malawi, because these issues that ACB is saying it's out of our mandate, they were already dealt with by the Reserve Bank in their report. And that's why they did recommend that those issues have to actually be attended to. And that's why I actually told the fund, attended to these issues. So there was no need to tell FIA or Fiscal to go and investigate issues that already fell within the mandate of the Reserve Bank, and the Reserve Bank had actually addressed them in their report. Thank you.
Lilongwe Mpenu, I'll ask you to share that one so that we go to Lilongwe Chirobwe, Palombe Machemba, in that order, please.
Thank you, Chairman. Through you, I would like to ask the Attorney General, who was the expert who recommended the price of 128 billion from 47 billion?
Mic off. Mic off.
Can you switch off your mic? Honorable AG?
Maybe a bit of clarity on that question. I'm failing to pin it down properly. If you could take it again, maybe in a summarized fashion.
In your submission, you mentioned about the expert advice on the price when you were asked by Luntha Kabula about the 128 billion being a red flag. You said no because you were taking an expert advice. I would like to know who was this expert who gave you this advice on the 128 billion?
Chair, the price range of 115 billion to 147 billion, that was, I think, what I saw in the documentation from EMJ. So they were not advising me. This is, they were advising the fund. So I was saying in my area statement that these were deemed as experts in the valuations. So that's where the issue of experts came in. So from the best of my recollection, that price band came from EMJ Advisory. Thank you.
The Attorney General, are you aware about the EMG status?
Perhaps if you could be specific, which status?
That they are not
Do you want time for one-on-one, or what is this? Because I see you're just going straight to the controlling officer. That's unprocedural, because I haven't given you that chance.
Thank you, Chairman. As you have put the precedence before some that have spoken for me, I would like to ask you, the chair, to give me enough time, like 10 to 15 minutes, so that I can ask the Attorney General.
Point of order. Lilongwe Chirobwe, we will not give you 15 minutes. I can give you 8 minutes. So, honourable members, you may recall that our members have asked even 10 minutes in this committee. So he's asking for 15 minutes. I'm saying we'll give you almost half of what you've asked. So we'll give you 8 minutes. Chukwawes, background noise, please. Proceed, Lilongwe Chirobwe.
Thank you. You as well said about the SPC that cannot provide oversight because it is not written anywhere. Why were you advising the fund?
You notice that even in my letter dated 28th December 2025, I begin by acknowledging that there was a complaint brought to my office by the Malawi Society. That's where my office got involved in this matter. If there was no complaint, there was no way I could have just jumped in and said, Trust Fund, what are you doing? I couldn't. So that's why I did use the language. My involvement was not proactive, it was reactive. So in terms of the powers of the SPC, I'm sure at an appropriate time the SPC will come here and answer the questions how she got the powers, but I was simply saying, when I combed through the trust bit, she is not being specifically mentioned. I think that's what I said.
Okay, you are saying that overpricing is not a sign of corruption. Are you sure a jump from 47 billion to 120 billion did not amount to corruption? Where would an AG stop government funds from being stolen if this is not corruption?
Chair, again, I maintain my position. Valuations were done and figures were presented. So I can't just say this is corruption. And perhaps to appreciate the fact that, Chair, you've already advised that the ACB is also looking into the matter again, I'm sure if there was corruption, it will be unearthed and appropriate action will be taken. Thank you.
In your response to Malawi Law Society, you said you will investigate. Who did you consult in your investigations?
I mentioned, Chair, in my letter that the ACB were actually part of the investigations because they did the conduct. That's why we have a report. But on the other hand, maybe up to now you may have noted that the report by the Reserve Bank, I haven't seen it anyway floating. If it was made available to this committee, probably it would have been floating somewhere. It speaks to the confidentiality of the tasks they carry out when it comes to matters to do with financial institutions. So I knew and I was aware they were already doing investigations and being an appropriate authority on some of the issues that were being raised. I did not have to go anywhere else because they have not only the capacity, but they have the mandate to do the investigations. Thank you.
Lilongwe Chilopa, you have 3 minutes to wind up.
All right. After the registrar had written you on 6th January 2026, what stopped you from writing another letter to the fund to reverse your advice of 28th December 2025, considering how explicit the registrar's letter was in ordering the fund to stop the transaction?
My very clear understanding is that every communication or positions that the Reserve Bank took were actually communicated to the fund. So it would have been redundant for me to actually go to them to say, you should do ABCD. Because in my letter, I said, can you look into this issue first? The letter by the Reserve Bank Governor on 6th January is saying the same thing. Look into these issues first, but satisfy him because he's the regulator. That's why I say that dossier, I hope the Reserve Bank Governor has either looked at it or they look at it. So these issues were well coordinated. The Reserve Bank was not only communicating to me, but it also communicated to the fund. So there was no need for me to change anything because what I had told the fund is exactly what the Reserve Bank said. Thank you.
Mr. Mbeta, you took a temporary relief preventing the Anti-Corruption Bureau from arresting you in 2015. Why was SCB trying to arrest you?
Chair, thank you very much. I'm sure the honorable member might want to engage in the Alexis Kamangira discussions. When I was coming here, Chair, I received a letter that told me what I'm coming here for. It's a letter dated the 25th February 2026. They detailed out the issues. That's what I came prepared to answer, so I don't have an answer to that question. Thank you.
AG, you're free to proceed in that manner. Lilongwe Chilobwe, you have a minute.
Thank you, Chair. Under your leadership as Attorney General, why didn't you advise government to stop this purchase? Because we have seen that you have stopped a number of such big procurements before. Why did you advise the government to stop this one as well?
Chair, maybe before I answer, the benefit of which procurements did I stop government from doing? Just to contextualize.
Thank you. Through this honor, we heard that all the transactions that were to do with the road constructions have been stopped. I understand it's through your office.
Actually, I think factually that could be incorrect. Maybe, well, I should just say I don't know how they were stopped because those are matters that would have been dealt with under different considerations, but not through my office. But also to emphasize again, the fund is run by trustees that have been given mandate and absolute discretion to invest. So you don't just go and take away powers that are properly granted by an instrument. The trust did. That's why I advised, can you attend to the issues, to the risks that have been raised? So you don't just wake up and say, I'm Attorney General, therefore take over powers that are properly granted by an instrument or a statute. The trustees have the power to invest and in their absolute discretion. But the best I could have done is advise them to say, as you exercise in that absolute discretion, can you attend to these issues? Because they go to the core of the transaction. Thank you.
Thank you so much, AG. Lilongwe Chilobwe, your time is up. Can I go to Palombe Machemba? Palombe Machemba, over to you.
Thank you, Chair. I have two questions to the Attorney General. Chair, my first question to the Attorney General. The Attorney General, you have told this honorable committee that the 17th January 2024 resolution not to invest in the Amaryllis Hotel does not exist. Attorney General, did you make an effort as part of your investigation to verify this information with the old board that reportedly passed the resolution not to invest? If not, why did you not verify or consult the old board? Chair, my second question to the Attorney General. Attorney General, were you aware that the Director General of ACB was in the meeting of 17th November 2025 to present the sale agreement and therefore was conflicted in this matter, regardless of who he was representing at that meeting? If you were aware, what do you make of the ACB's conclusion that there was no corruption in the sale of Amaryllis Hotel? Thank you, Chair.
Thank you so much, Palombe Machemba. Attorney General, over to you.
Thank you, Chair, and thank you, Honorable Member. Like I said, when we questioned the fund, the trustees, and the acting principal officer, whether indeed there was a resolution or some minutes relating to is a resolution not to invest in the fund, in the hotel, they said no, it does not exist. They've never seen one. Ordinarily, these are the custodians of the documents. Therefore, I did not go further. But what is also very critical is the fact that when you look at what the SCB found as well as the Reserve Bank of Malawi, you find that they ended up with the same conclusion because of the information that they were given. If any one of these reports, which in my view would have saved and did save as a competitor for me in terms of what I found and what they found, if there were to be any inconsistencies, it would have ordinarily called for a further probe. But those two institutions having found facts in the same manner that I did not find any reason to probe beyond that. Thank you. Okay, the second question of the SCB director being involved in any meeting, I've just said it from here. I'm not aware. Thank you.
Thank you, AG. Allow me to give space to Chikwawa North. Chikwawa North.
Thank you so much, Honorable Chairperson. The controlling officer, what was your interpretation on the concerns raised by the Registrar of Financial Institutions on the sale of Amaryllis Hotel? Question number one. Question number two, what is your current position on the matter at hand? You as an Attorney General, what is your current position now that you have seen the situation that Malawi is in? Thank you so much, Honorable Chairperson.
Thank you so much, Chikwawa North. Attorney General, you may take that one from Chikwawa North. Over to you, sir.
Your indulgence here, Honorable Member from Chikwawa North, your first question, I didn't get it clearly.
Chikwawa North, can you retake your first question?
Thank you so much, Honorable Chairperson. The controlling officer, what was your interpretation on the concerns raised by the Registrar of Financial Institutions on the sale of Amaryllis Hotel? Thank you, Honorable Chairperson.
Thank you, Chikwawa North. Attorney General, are you okay with that?
Yes, Chair, I've gotten the question loud and clear.
Proceed to respond.
Yeah, my interpretation was as plain as it could be. There were prudential risks that had to be attended to before they could proceed with the transaction. That's why the governor indicated that those have to be addressed first. So it was that simple. That's why I repeated it by telling them, can you address these prudential issues? That's the best I could have done because those had to be addressed first. Current position, well, We are at a point where I think some facts are emerging from all over the place. If all those facts were put together in a conclusive setup, then I would be able to say, now this is my position. But at this point, it's difficult to say this is my position unless all the facts and supporting documents where necessary are made available. Then it will be possible to actually take a position. Thank you.
Thank you so much, Chikwawa. North, I think you're on page. Can we from this round? There was Lilongwe East. Lilongwe East, please.
Thank you so much, Chair, for giving an opportunity to the people of Lilongwe East. The controlling officer, following the OPC meeting in March 2024, the then principal officer issued conflict letters to the seller. However, an independent legal opinion from Likongwe and Company identified these letters as the main source of risk, giving the fund only an 80% chance of success in a lawsuit. Did your investigations consider the legal implications of these letters, which were issued direct as a result of OPC's directive? Second question, the legal opinion suggests those letters created a 20% risk of loss. Given this, why did your advice not caution the board against proceeding? The final question, in all fairness, Attorney General, having reached this far, as Attorney General, do you still see your decisions serving the common good for our great nation? Or you are now regretting that you could have done much better than this? I thank you, Chair.
Thank you, Lilongwe East. Attorney General, kindly attend to those from Lilongwe East. Over to you.
Thank you, Chair, and thank you, Honorable Member. When you think of the comfort letters that the OPC mandated the fund to issue to the seller, I really don't know what the wisdom was, because maybe they had reasons why they were doing that, or probably because according to the minutes they are saying lenders were on the seller's neck. The question is, to what extent should the buyer, in this case the fund, get involved in issues to do with the lender of the seller? So it's difficult to really appreciate why really such a decision was made, but I'm sure that at an appropriate moment somebody will be able to explain. Right? Indeed, yes, there will be a risk, because depending on how you draft your letter, are you drafting in such a way that you are hanging yourself, or there are some indications that although you're giving that comfort, but you're not taking any liability out of whatever may happen. So I would agree that yes, it's a risky issue, and certainly one would want to tread carefully on that. Now, when you talk about me advising the fund against proceeding with the transaction based on those letters, at the point in which the issues were brought to my attention, the issue of these letters was not part of it, so I didn't consider them. They were not available to me. Decision saving the greater good of this nation, yes. If I had told the fund proceed without telling them first address the issues, then it would have been a disservice to this nation. But I told them to address the issues, and that's the exact thing that Reserve Bank told them. If I had contradicted Reserve Bank, who is essentially the regulator of financial institutions, then perhaps that conclusion would have been made. But actually, I find myself fortified in the fact that I gave them advice, which was correct, to attend to the prudential issues first. Thank you.
Thank you, AG. Honourable members, I see Gilaz Lunyungwe. I see Mulanje Southeast. Mulanje Southeast, take to the floor. There are many times when we've recognized and started from the last. So this is not an abnormal occurrence. Yeah? Unless if in Mulanje Southeast is yielding to Chilazu Lunyungwe. Chilazu Lunyungwe, take to the floor.
Is it because of his chair?
Lilongwe Chirobwe, if you switch on the mic before being recognized, I will be left with no option to give you 1 of 5. Let us restrict ourselves to the issues at hand and ensure that we remain focused and serious to these deliberations. Lilongwe Chirobwe, I think you've taken note of that. Chilazu Nyungwe, kindly take to the floor.
Thank you, Chair, for according the people of Chilazu Nyungwe an opportunity to ask 3 questions. The first one is, are you aware that the fund is guided by several rules other than the trust deed? Specifically in this case, I'm interested in the investment policy statement, which prohibits any investment taking place or this type of transaction taking place without the presence of a fund manager. So in this case, we do not have a fund manager. I want to know why the controlling officer, in his wisdom, did not pick this point up. Second question, as part of your investigation, you submitted to have met the board members for questioning. Which board members did you meet, and are you able to actually name them? I'm saying this because as a committee, PAC was able to hear from all the board members, and in that we have learned that there are some contrasting statements that are coming from the board members. For instance, the board chair and the acting principal officer, they were telling the committee that the meeting of the 17th of January 2024 did not happen, whereas other board members told us that this meeting did happen. So as the AG, did he take any effort into verifying such matters? Third and final question, the statement that if overpricing is not an indicator of corruption, I think that's quite interesting. I think most Malawians find that interesting. So I'd like to know from the wisdom of the AG, what should Malawians consider as perhaps an early warning to corruption when we have seen so many assets being sold and bought at questionable prices, and especially when public funds are involved? Thank you very much, Chair. I'll stop with those 3 questions for now. Thank you.
Thank you so much, AG. I'll give you space to respond to the 3 questions from Chilazulu Nyungwe. Take note, AG, that at some point the live beaming will go off because Parliament is still meeting, and on Wednesday, like today, Parliament doesn't sit in the morning. So the other members have been foregoing their time. And there is no any allowance attached to this meeting that other members have been, and they are not intending to draw any allowance from anywhere because they have a duty to perform. So at a certain point, to go offline so that our TV can focus on the parliamentary proceedings. Traditionally, committees don't sit while Parliament is sitting, but it's not within the standing orders. But we've always respected the House because we sit as a committee on behalf of Parliament, and I sit as a chair on behalf of the Speaker. So once the Speaker is attending to the House, it is expected of us to go in the House. So this, it means we only have about 54 or 56 minutes before 2. So at 2, we'll be going into the House. So in the event that you've noted that others are leaving, especially the TV, it becomes a point. So give it to you to respond to Chilaz Lunyungwe, the 3 questions.
Chair, point of order.
Yes, what has gone out of order, Chikwa West?
Thank you very much, Chair. Looking at that, our inquiry has always been live on TV. Don't you think maybe we can make sure that we finish our questions? Maybe we give each other maybe 5 minutes or 10 minutes, and then while we finish the meeting, and then the cameras can go to Parliament. Because I'm looking at a situation whereby we're saying let's conclude the matter without the cameras. It might look different. So maybe if you can control the time, that maybe the camera people can tell us how many minutes they will need to go and set the cameras. That means we can put our questions in so that we should be done by then, rather than saying let's continue even off mic. It might not maybe give off camera. It might not give a good picture out there. That's my suggestion. Looking at that, almost all members have already asked their questions, and the AG has already tackled those questions. Thank you very much, Chair.
Thank you, Chikwawa West. But this will not be the first time since we started the inquiry to take that route. You may wish to be refreshed with the fact that when you were away, Reserve Bank and the Public Accounts Committee were having the same interface, and the TV requested that they leave at 12:30. We negotiated for 1 o'clock, but when they had left, we proceeded to engage Reserve Bank up until we exhausted all the relevant questions. So we had already said that, maybe you were not aware, but basically that's what happened when Reserve Bank was here, and we proceeded up until we concluded, because we don't want to rush through, so that even the AG has to give his responses in a manner that is not gagged, but gets to attend to each and every question conclusively. So we already set the precedent. AG, kindly proceed.
Thank you, Chair. Thank you, Honourable Member from Chiladzo Nyungwe. The issue of fund manager was raised as one of the issues that had to be attended to in the Reserve Bank report, if my memory serves me right. So I didn't have to be raising issues when Reserve Bank has raised and has actually advised on what to do to actually resolve that issue. So yes, in my wisdom, I knew about the policy, and in fact, Reserve Bank had raised it. So when I was saying attend to the issues, this was one of the issues. Thank you. Board members, I do recall there were about 7 people that came to my office, but I can't remember name by name. The only 2 people that I remember, because probably I knew them prior to this engagement, were Mr. Chizaso Nyirongo as chairperson, and also Mr. Boyd Hamira as acting officer. So those ones are the ones that I do remember. But again, if I invited the board members and they came in those numbers, I don't think there was any reason to think that you have to go look for other members who did not come. Overpricing, maize was overpriced just a while ago. Was that corruption? It wasn't. There are so many factors that go into prices. So it shouldn't be taken that the AG is saying that overpricing is not a sign of corruption. All I'm saying is that when something is being overpriced, you need to go and find out why it's being overpriced. You need to understand the environment in which that price was tagged and So when you look into all those issues, then you realize that when maize was going at 100,000, now it's going at, is it about 40,000 a bag? That wasn't corruption. It was just something else. So many factors. So all I'm saying is that when you look at a price and you say, it's too high, you got to see what factors are at play without necessarily saying that. And then the other issue, if it comes to government contracts, those contracts are vetted at different levels. You have IPDCs, then you have the PPDA itself. They're competent to comment on prices. So I do believe that there are safeguards that deal with issues of overpricing without necessarily looking at it as corruption. There could be so many factors at play. But where there's evidence that overpricing was because of corruption, I'm sure it could be dealt with accordingly. Thank you.
Mulanje Southeast, over to you.
Thank you, Honorable Chairperson. I won't take a long time, and if you would indulge me, I just needed to have 3 or 4 minutes. Thank you, Chairperson.
Kindly proceed.
AG, in your presentation to this committee, you have indicated that the trustees of the fund have absolute powers, and you have referred to that on several occasions. Is that right? Did I get you right? That the trustees of the fund have absolute powers?
Chair, I see the absolute discretion because that's what the trustee gives them.
You said absolute discretion and not powers. So you were on record for having said absolute powers, and that was a mismention on your part?
Even if you were to interface those expressions, somewhere they might be one and the same thing, but I have specifically said absolute discretion because that's what the trustee says.
AG, have you seen the trust deed? And if you have you ever gone through it?
I have it with me here.
I would like to draw your attention to Article 14.2, A and B, and Article 14.4, B and C. If you'd be kind enough to read that out to the Honorable Committee, please, Honorable AG.
14 what?
14.2, A and B.
In discharging the powers under this article, the deed and the fund rules, the board shall have regard to A, directives, guidelines, rulings, information circulars, and policy statements issued by the registrar. B, government regulations, orders, and notices affecting pensions or tax on pensions.
Honorable AG, please proceed to 14.4 and specifically B and C.
The board shall not be subject in the exercise of any of their powers in relation to the fund to direction by any other person except to B, registrar's directive, C, a direction given the minister under financial services laws.
In your position as government advisor, what would
be your interpretation of the two pieces of statute that we have just read out?
Chair, that just, in my view, is telling the trustees that even when they are exercising their absolute discretion on what investment to make, they will have to have regard to these issues and also be answerable to the Registrar of Financial Institutions. I did mention earlier on that this is a whole legal framework beyond even this trust deed. There's a whole legal framework that the Registrar of Financial Institutions uses in supervising these financial institutions. So to me, this was just a matter of recognizing that there's a whole legal framework that, like when you talk about directives, these directives are issued by the Registrar of Financial Institutions under certain laws that they use. Government regulations, obviously, once in a while, government to issue regulations or even enact certain laws regarding certain things. So there's no way you would expect that the trustees will act without regard to those laws. And I think that's more or less the spirit in 14.2 and 14.4.
To 19.0 and specifically 19.1.
Should I read? 19.0 is conflict of interest. 19.1, any trustee, advisor, or employee of the fund who is present at a meeting of the board or committee of the board at which any matter in which he has an interest is being considered shall disclose to the chairperson such interest as soon as practicable after the commencement of the meeting.
Honorable Eti, were you aware that Mr. Chizaso Nyirongo was present in the meeting of the 6th March 2024 and that in that particular meeting he had purportedly been given powers to provide legal advice to the pension fund, and subsequently he was appointed chairperson of the fund? And if you are aware, did that not pose as a conflict of interest? And if it did, what was your advice when you were making your submissions? Secondly, were you aware that the acting principal officer was at a point a trustee, and he had subsequently been appointed to the position of acting principal officer, and a position that was normally supposed to be reserved for officers within the institution and not board members? What was your advice, having gone through the same? Thank you.
To begin with, Chair, I was not aware about the meeting of March until recently after the Law Society had presented, because in their document, which they presented here, as it's circulated on social media, that's where, going through it, I found those minutes. So I have them through that. So there's no way I could have considered issues of conflict of interest, because that fact of these people having areas served in certain capacities was not made available. But also to notice that if I was made aware at that time, I would have probably probed on whether they complied with 19.1, where they declare that I was once in this capacity, therefore I'm in this capacity. But I didn't go into that, because that factual issue was not made available to me at the time of giving the advice. Thank you.
Thank you so much. You may agree with me that even in today's deliberation, the former SPC has been reflected. AG, as a Public Accounts Committee, we had a meeting even last evening, And we have instructed our legal department to do the needful, because that's experts who anchor this committee when it comes to legal guidance. So they will be getting to other institutions to ensure that Parliament gets to have everyone. Like we've indicated, as Public Accounts Committee, we just have to do our part. And going forward, we're going to also get other individuals and Parliament to ensure that we are within our mandate, and they help us to get to the bottom of this issue. Since every member has almost asked, honor members, maybe since we knocked off at around 12 midnight, but as of 8:30 you are here and you're supposed to proceed into the chamber. This is 19 after 1. I would like to propose that maybe we curtail, unless if there's a member who feels there's something that he wants to ask. Honor members, anyone? I see Lilongwe Chirobwe. Lilongwe Chirobwe, please.
Thank you, Chair. We're going forward. I wish to ask you that you might summon the SPC and the owner of Amaryllis hotels. There are one or two things that they really need to come and clarify here. Thank you.
Before I get to Zomba City North, I think every day after the meeting, when the stakeholder is gone, we sit, discuss, and agree how we're going to proceed. And I don't want to be seen like a chair who imposed his opinion in how to handle these things. So, Lilongwe Chirobwe, I'd like to ask you to wait or hold. When we meet, then we agree as a committee on how we want to proceed. In that way, we will preserve the integrity of this committee and the integrity of Parliament. If I may guide that way, I think I'll have comfort in my soul to ensure that we are all pulling in the same direction, so that we can land this inquiry as per the expectations of Malawians. There was a point of order from Zomba City North. Zomba City North, what has gone out of order?
Chair, it's exactly what you have ruled on. Therefore, I yield. But suffice to say that you had a proposition in mind. I wanted to second that you curtail the inquiry for now, so that we proceed to have lunch and then we join plenary this 2 p.m. afternoon.
Thank you so much, Zomba City North, for yielding. And once again, let me thank you, honor members, for your resilience and remaining focused towards getting information. Attorney General, you may give your closing remarks, because you've been sitting for some time. You were here, you arrived here somewhere around 8:30. And as a committee, we appreciate that you've been here up to now. So you may say your closing remarks. Over to you, Attorney General.
Thank you, Chair, and thank you, honorable members. Perhaps let me just begin by making one comment on the issue of absolute discretion. I answered in view of how the questions came through, but I need to emphasize that in law, when you say somebody has got absolute discretion, it doesn't mean they must break the law. It doesn't mean they must not obey certain rules and regulations. They can decide on what they want to invest and at what price. But they have to be in check, because they have to make sure that in what they're deciding on, which actually no other person can actually dictate to them that no, buy this or don't buy that. Yeah, that's the absolute nature of the discretion, but they still have to observe rules, regulations, and any other statutory requirements. So the absolute discretion that the trustees have did not mean they can break the law and be taken that they have absolute discretion. That's not what absolute discretion entails. It just tells you that you are within your powers to decide on certain things as long as it's not illegal. Thank you very much, Honorable Chair, Honorable Vice Chair, Honorable Members. I would like to end by saying, I think a lot was said. People thought I was avoiding this committee. And I think, Chair, at some point you burst into, some wonderland. But my office, with the busy nature and there's so many institutions that I attend to, I might find myself sometimes in a position where you're able to tell one institution to say, I'm not able to come, but I'll come later on. So that was the spirit in which I wrote to the Clerk of Parliament that I was not available because of other engagements. Otherwise, here I am. I have appeared before the committee, and I did, even in my letters, indicate that I'll be available. So the perception that people out there had, thinking that the Attorney General is avoiding the committee, is hopefully cleared. There's nothing to avoid this committee for. Most importantly, my office has that duty to attend to any issues that are of public concern in as far as matters of law are concerned, and certainly this committee is one of the committees that ought to be attended to, and that's why I came. And summons were issued. Subpoena wasn't necessary because I had indicated I will come, and I have come, Chair. But nevertheless, just to put the record straight, that there was no need to think that the AG is avoiding this committee. It's my duty to come, and I hope that through my presentation and also the responses that I've provided to various questions that the honorable members put across, members of the public, and indeed this committee would get clarity in some of the issues that were within my knowledge or at least capacity to tackle on. Thank you very much.
Thank you so much, Attorney General, for availing yourself, like you've indicated. Members were just acting within the powers that they have, like I indicated earlier on, one of which being to summon or subpoena any person to attend and give evidence before a committee. So basically, we were just doing our role as members of parliament, providing oversight and representation. Where need be, we will proceed into legislation because in our view, as Public Accounts Committee, we've noted gaps in terms of how other things are being done. But that's for another day because those are going to be recommendations. Recommendations that are going to come from all members of parliament who are part of this Public Accounts Committee. The inquiry has unearthed so many things. So when we subpoenaed you, basically we were within our powers. Like Monday, you were supposed to appear, but the letter about your not appearing on that day came about around 9:15. And that stage, like in my case, I was going through something which was a family issue. My wife was in a theater at the same time. So there were a few things that were happening. So I had abandoned everything just to attend to this issue because I felt, in my view, it generated national interest. And a lot of talks were flying around that this committee had pocketed money. And I knew if I had taken off and I'm seeing maybe in Halal at that time, people would have looked at this committee in a different way. But I had to take on the weight and be strong as a man while serving this nation. So that's why some of those things happened, and we had to be guided by our our legal counsel as well as the legal department as a whole. So be at ease. I think the deliberations today have been cordial, and the involvement that everyone has been accorded to you in this chamber, in this parliament. And we're looking forward in the event that we want more information from you as a witness, not as an Attorney General, that you're going to give us. That's the nature of our job and how we're going to proceed, so that in the end we save the country much, much better. Because it is a view of the committee that teachers out there, they are desperately looking forward to having their money protected. We have doctors out there, we have nurses, we have a lot of civil servants, police officers who are focused on this thing. So when members of this committee become emotional, it's because they are being driven by the people in their constituencies who are looking forward to having the money in their old age protected. So AG, thank you so much for your coming. You may take leave at your pleasure. Thank you so much.
Luntha Television stands as an autonomous